Hi, this is Kim Benjamin with the Missouri DWI and Criminal Law Center, and Craig Napier, also with the Missouri DWI and Criminal Law Center at the Benjamin Law Firm. And tonight's topic is for all those parents out there who have kids who may or may not get into trouble this summer, but you want to be forewarned and prepared for what happens if my child gets arrested or the police want to talk to my child. I'm going to start with an introduction. Craig, go ahead and introduce yourself.
Okay. My name's Craig Napier. I've been an attorney since 2003. I initially was out on my own for about 5 years, and then I did about 10 years with the public defender. I left the public defender and did about a year doing juvenile work part-time in Johnson County, Missouri, Warrensburg. And worked with a judge pretty close on a number of juvenile things. And then I came to work a little over a year ago now with the Missouri DWI and Criminal Law Center. I've focused much of my practice on trials and being in the courtroom, and certainly that 8-9 months I was in the juvenile court every single week was lots of trial type work. As we'll see, it's a little different. Live in Kansas City with my kids and my wife and our dogs. I have a kid going into high school, so I am kind of worried about this one myself.
So this topic rings true for you. Plus, you help families whose children get arrested, so you have experience in this area, and so do I. I've been a criminal defense lawyer since 1996. I started out at the public defender's office in Kansas City, and then went to the Sedalia office, and then to the Lebanon, Missouri office. Finally came back to Harrisonville, Missouri, my hometown, and opened my private practice, where I have focused on criminal defense, DWI defense, and Craig, because of his juvenile court experience, he handles a lot of our basically criminal court for children. When children get arrested or get accused of a crime, what happens next? How do parents help their kids through the process? How do parents prevent their children from getting into trouble? Those are two of the topics we're going to talk about today. We're doing this topic tonight because it's July 4th weekend, and kids have all kind of graduated now and are kind of, out and about for summer. And it's a good time for parents to maybe take a look at this and talk to their kids and have a heart-to-heart conversation about what happens if you get in trouble, what happens if law enforcement wants to talk to you. So Craig, let's start with you. You have a PowerPoint here to kind of give us some perspective and go through some of we're going to just foundationally, we're going to talk to you first about the juvenile court system and what that is and what that looks like in Missouri.
Right. And before I start clicking away, I did want to say that always, especially teenagers, but you should always tell your children that if a law enforcement officer wants to ask them questions, or if they're in trouble at school and an adult wants to ask them questions, that they should ask that adult to call you. That goes whether they are 10 or 11, 14 or 15. Hopefully, if they're being accused of something very serious, getting mom and dad involved will also get an attorney involved, because that is the stage where I see most of these cases become good for the kid or bad for the kid, depending on what happens in that interrogation. But you'll hear that from me throughout the hour tonight. But I did want to say that up front, because I had a science teacher used to call it the motto El Big O. That is it. This is the big thing you need to take away tonight. Anytime your kid's accused of doing something wrong, the police or any adult wants to question them, they need to call you, and hopefully you'll call an attorney. So let's get into what juvenile courts are in Missouri. Anybody under 17, and that is 16 and below, as soon as you hit your 17th birthday, if you get into any trouble, then you will go to the adult court. Any person who is under the age of 17, if they're accused of a crime, it goes to the juvenile officer. There are 35 juvenile officers all around the state of Missouri. Um, Juvenile officers are usually broken up by court jurisdiction. Um, Jackson County has a large juvenile office. They have attorneys on their staffs. They have deputy juvenile officers. DJOs is what you'll hear those referred to. I'll probably refer to them as well that way, but it's DJO for deputy juvenile officers. And then they have support staff, folks who answer the phone and do all of that. Every allegation doesn't go to a prosecutor, like if you were accused of doing something in the state and you're an adult, it goes to a juvenile officer. Juvenile officers, I've dealt with a few dozen. They're all a little different. Some of them are very hands-on. Some of them are kind of like the smoking guy in the back room that never really shows his head anywhere and just tells his DJOs what to do. But if you're ever accused of something and the juvenile office gets involved, the deputy juvenile officer, the DJO, is going to be the person that is kind of your first contact with the juvenile office. DJOs wear lots of hats. So juvenile officers are social workers in a lot of ways.
I like your picture of Mother Teresa.
Well, she is the ultimate social worker, that I believe. So she is emblematic of them being there to help kids. I mean, because we're not just talking about crimes. This could be kids not going to school and being truant. That's what they call a status offense. That is more about them doing something that's bad for themselves. Deputy juvenile officer would get involved. They can just, find out what's going on at home.
That's what I was going to say, Craig. Another part of the juvenile officer and why they carry or wear the hat of social worker is because part of the juvenile justice system in Missouri, part of it is looking at why is the kid acting out or making a mistake or committing a crime? And is there something going on at home? Is there maybe the kid is struggling with parents who are separating or parents who are fighting, or is there abuse in the home and the child's a victim? They're looking for why is the child messing up, which is completely different than the adult system, which unfortunately in this state and in this country is solely looking for how do we punish you for your behavior as opposed to teach, train, prevent, and figure out the why, so maybe we can help this person never get in this trouble again.
Right. So I completely agree with you. And the statutes even say that this is a best interest of the child. It's just like child custody anywhere else. The judge is supposed to consider the child first. Now, where that gets dicey and where I think judges really struggle with that is if a kid, especially a mid-teen, 14, 15, 16-year-old, is accused of something pretty bad.
Something violent or sexual.
Exactly. Then it's tougher for the judges to focus on the kid and what's going on with your client if you're a defense guy versus what's going on with the victim, because our system is so victim-oriented. Not here to debate good or bad there, but just saying that's where the rubber hits the road. It's easy if you're not getting enough food at home, so you're falling asleep every day in class. They get a referral. They figure out, well, let's get them signed up for some benefits, some help to make sure this family gets fed. So that's kind of the Mother Teresa role, and we'll kind of see how they play that out a little bit further. They're also don't be fooled by Mother Teresa, because they are the eyes and ears of the juvenile court and the juvenile officer. So if they hear you say things that are incriminating or admit that you're guilty of something, well, then they're going to write it down and it's going to be in their report. These are the guys that if they stop by your house to see you and check on you and you've got a bong sitting in your bedroom, well, they're going to go tell the authorities that. So while their stated mission may not to be there to go out and ferret out, crimes. If they see something they think is wrong, or they see you breaking the law, they're going to report it to the juvenile court or the police. There are also the people that come and they have to be involved in locking a child up. Now we'll get down to a whole section on custody for children, because that is a pretty tough area here, but they are the people that would show up to put somebody in custody.
I love this picture. Chitty Chitty Bang Bang. That's the
Yes.
scariest jailer I've ever seen. I remember that movie as a child.
The kid catcher, he creeped me out the worst when I was a young kid, but
Yeah.
I show my age with my pictures here, that's for sure. And then the last person that they kind of act like sometimes, and this is some of the most effective ones, really kind of act like your big brother, the guy who's hanging out and kind of just the older cool guy or girl. Some of them really pull this off pretty well, so they really kind of come off like your friend and your buddy, and maybe in some ways they can help you a lot. They can also hurt you a whole lot, so you really want to make sure that you understand who the deputy juvenile officer is and treat them with respect, but don't always give away the farm, so to speak. And parents need to be aware of who they are as well.
Yeah, I think that's important for parents to know, and why you should talk to a lawyer first if anybody is looking at your child for any sort of criminal or bad behavior.
Right, because the statutes say that if a officer is going to question a juvenile, that they have to call a DJO. They have to call the juvenile office, and usually they send a DJO. The DJO is the person then who reads Miranda, and also explains to the child that they're not there as their attorney. They're not there to ask questions. They're just there as a neutral observer.
And most parents don't even understand what that means, because most parents that I work with over all of these years feel that their kids are still their kids. I mean, I'm 50 years old, and my mom called me today and told me to drive careful. It's a very dangerous weekend, July 4th weekend, to be driving. Parents, especially your youngsters between 17 and 25, it feels like those are still the tender ages. We know that their brains are not fully developed. We know they're still highly prone to make mistakes and get themselves caught up with law enforcement. But unfortunately in Missouri, our law, unlike most other states, actually don't consider 17-year-olds adults. And 18 is usually the cutoff in many states, but here in Missouri, it's younger unless you get your legislature to start changing that for us. And the other thing is that young children, even younger than 17, can find themselves in custody in a juvenile detention situation and ultimately transferred to an adult prison at the tender age of 17. So, and I'm sure we're going to talk about that too, Craig, but parents need to know this is serious. This is not trust your principal at the school, trust your DJO, trust that the police are there to help, because unfortunately that's not the case like it was in 1970 when some of us were kids. And if we got in trouble, they took us home because our parents were going to spank us and punish us much worse than any justice system was going to.
No, I can remember getting sent home from school and having to walk that 1.5 miles home. They would call the juvenile office in most of these school systems now to say, hey, this kid's getting kicked out of school. He's,
before they'll call the parents. And the parents' hands are tied, because the minute you punish your child like we were punished with spanking and severe, removal of certain items from our lives, people start throwing around the word child abuse and child neglect. And I've seen plenty of parents get in trouble for taking a cell phone away from a kid because the parents own the cell phone, but the kid doesn't get that. And it becomes physical, fighting about a cell phone, for God's sake. Right. And these are not things that we dealt with when we were kids ourselves.
Yeah, for sure. Yeah, and, while those child abuse cases end up in the same court, they are very different. So that'll be a topic of another day. But that it is very real that child abuse and neglect dovetails with all of this. especially if you have a kid that you're physically correcting, you can get in quick trouble with the juvenile court.
And just to clarify, because I have represented plenty of parents, dozens of parents who've been accused of child abuse for corporal punishment, physical punishment. Right. And Missouri actually allows corporal punishment, reasonable corporal punishment. The problem is that who's judging what's reasonable is usually a prosecutor who probably doesn't have any children, who probably doesn't spank anybody. And that's where we get into trouble. So I've had to go to jury trial because a prosecutor just honestly is clueless about parenting. And then the jury has to tell the prosecutor, no, this is not child abuse. This is normal discipline, and we accept this in our community. Unfortunately, that's a very stressful experience for that parent, not to mention expensive.
Right, and that's after they've dealt with the juvenile court on the child abuse and neglect case that isn't even criminal. But yes, I completely agree with you. Referrals are really what they talk about when anybody reports wrongdoing to the juvenile court. The police are mandated, if they witness a crime, they don't write a kid a ticket, they write a referral and send it to the juvenile office. Now, if you're over 15, there are a few things that you can go to municipal court for. So traffic tickets, that kind of stuff, don't go to the DJO or the juvenile office. But everything else, if you're 16 and below, goes there. Your school can report to the juvenile officer any kind of bad behavior that they think's necessary to go to them. Medical professionals, you hear about mandated reporters. Not really the same thing here, but basically if you are in a community and you know the phone number to the juvenile office, then if you see something you think is objectionable, you can call and make that referral, and they're duty bound in some situations to follow up on that. Family can also, I have actually had parents call the juvenile office to say, I can't handle my kid. Now, I would really urge parents to do something other than that, because then you're leaving the future of you and your child up to a judge who you don't know, who doesn't know you. But it is possible. It can happen. Family services, Division of Family Services, obviously, if they're involved with family, they can make a referral, not only for those child abuse and neglect cases that we talked about, but also any kind of crimes that they see a juvenile may or may not be doing. Also, those status offenses, which is, not going to school, doing something that's injurious is the magic word, but it's anything the kid's doing that can hurt themselves. Okay. And once that happens, it goes to the juvenile officer, and they can pursue these referrals in different ways. So it kind of depends on the circumstances. So we're looking at if it's something like I'm not going to school, or I'm not getting up for school. So chronic lateness or chronic, I've represented a kid in juvenile court that missed like 93 out of 120 days of class one semester. And, they don't have to necessarily open up a case and take you in front of the judge. They can do what's called an informal adjustment. And that is where the juvenile office believes that whatever you've done is not so monumental as to warrant dragging you in front of the judge, but they do believe that you need more services. So they can just say, hey, mom, take away the cell phone at 8 o'clock every night, shut the lights out at 10, and I bet you've got a chance at getting your kid up around 6 or 6:30. So that can be some small stuff. They can also make referrals. So if there's maybe some sleep issue, or if there's some kind of mental health issue, or just something that could benefit from some counseling, the juvenile offices have the power to refer folks to different offices and agencies that might be able to provide services that are necessary. It can look, I mean, it can really be a wide array of things, from, you know, even if the kid's maybe smoking pot at 15, 16 years old, they don't necessarily have to take them in front of a judge. Now, I think in most rural counties, they probably would take them to a judge, but they can also just refer them to a program for juveniles and abusing pot. So they can also do supervision. Go ahead, Kim.
Yeah, before you moved on, you were talking about services. And if I'm a parent listening to you, I am wondering, is my life experience going to be that these people in the government are telling me what to do and then not also paying for it, helping me get my kid to the class? Like, what, as a parent, what's my responsibility to follow these government guidances, like you said, guidance?
Well, so in this case, I put it up here, informal adjustment. It's voluntary. So it's not court ordered, but they will make the parent sign the agreement with the kid. So it's basically, well, a lot of the juvenile officers and DJOs take the position that if a parent's not holding up their end, it's not their problem. The kid is still the one not doing what he's supposed to do. Now, I think that is completely ridiculous, and most
To
judges
punish the kid for the parent's failure.
Right. So the way this looks like is informal adjustment. They'll do a lot of the legwork initially. They'll get the school records together. They'll get any kind of police, you know, if it's a minor thing, a police record together, and then they'll have the family come in and talk to them. And if it's a relatively minor thing, the kid's not doing anything crazy, and it's maybe the first time, they'll put this informal adjustment agreement in front of everybody and say, hey, here's what we want. You go to school every single day. You do this, you do that. Those sound really good because you hear, I'm not going in front of the judge. But the problem is that most of the time they're kind of under duress because they say, if you don't want this, then we're just going to file a petition and we'll take you in front of the judge. So if you don't have a lawyer there, especially, these are not always the ideal thing. As Kim got honed right in on, if you are a family that has one car and has to trade, one person works second shift and one person works first shift, and your kids walk to school or ride the bus, mandating that you take your kid to a 6 p.m. class 3 days a week may not be in your wheelhouse. It may be impossible. And if you were to express that to a juvenile officer, or you were to express that to the people who are kind of pushing this adjustment agreement on you, they may say, well, you just got to figure it out, or else we'll file the petition and take you in front of the judge and he'll order it. Well, I mean, there are always alternatives, right? So that's why it's so important, even in these kind of informal adjustment conferences or get a lawyer, pay him for a couple hours time to go in and talk with you. It doesn't have to be a monumental commitment, but I'm going to sit there and I'm going to say, no, this kid doesn't need that. He needs this. And here's my idea of what might work. And most of the time they take that a little better from somebody who will stand up to the judge and say, hey, judge, here's what I think should happen. And a lot of time judges agree with me. So
And the other thing is that parents sometimes, it's not just the one car situation and just the sheer amount of events they have to take their kid to under these informal adjustments, but sometimes they feel they're not able to afford the services that they're being told to do, the therapy, maybe a psych eval, or take this class on shoplifting, whatever the situation is. So talk a little bit about, what does the juvenile office do for those situations where it's an affordability issue too?
Right. Well, actually, the juvenile office, when I say they can make referrals, usually if they make referrals, it's to agencies that they have agreements with, and they pay for most of it. Now, when I worked for the juvenile office, I will have to say I was working mostly for folks whose parents were at or below the poverty line. Pretty, pretty at-risk kind of kids. But if they send you to a class, it's usually paid for, especially because, like you honed in on, it's therapy and things. If you don't have insurance for it or you don't have money for it, very difficult. So my experience, and again, I haven't been in all 37 juvenile offices, but my experience is a lot of times they're going to provide that to you. A lot of times, though, they get around it by making you do classes, but the classes are in the juvenile office. So there's usually one DJO that teaches the boys being good class or whatever it's called. They have classes about, they have boys class and girls class, and they have probably, they do some little bit of light drug counseling there too. And then they would do like some, probably an anti-theft class. As kids get older, they normally do some kind of budgeting classes and things that, if the kids get those first jobs, that they can help with that. I mean, there are some little things that they do. But as far as the doctors and the evaluations, a lot of times they send those to Compass Health, or, it used to be Pathways, that has state contracts. One thing I just clicked up there too is sometimes these informal adjustments can include an admission of guilt. So that would be something that I would never agree to, because if you admit that you're guilty and sign the form, and you've been given all your rights with your mom or dad sitting there, the judge can probably use that against you down the road. And as we'll see, if you get to a juvie trial, they call them adjudications, but it's the same thing. You have all the rights that an adult defendant has in adult court. So that's the only time in juvenile court where they have to bring witnesses in. You get the confrontation rights. So there's a slide on that later, but they can include admission of guilt, and I just think that's just crazy. And if your kid doesn't end up being successful and ends up getting a petition filed against them, or you end up in front of the judge, they will always note for the judge, he was not successful on this informal adjustment agreement, and explain the reason why. And most of the time it's going to be because he just didn't do it, or, they won't really look to make that a positive. It's always used as a negative. Can you get through an informal adjustment and never go back to juvenile court again? Yes, no doubt about it. But be very careful what you sign, certainly without a lawyer around. Because I think that a lot of times they're very excessive. They go a little overboard, and they ask for things that aren't necessary. So those are just some things to be kind of on guard for.
And the other thing, what you just said,
yeah.
When a parent says to the juvenile office, this is unnecessary, this is excessive, you're going overboard, my kid doesn't need this, they get defensive. They, being the juvenile office, gets defensive and starts to think, I can parent your kid better than you can. And that's the dynamic that all of a sudden gets created. But when you get a lawyer involved and the lawyer says no, it helps because it takes some of the pressure off the parent. The parent is able to allow the lawyer to advocate for their kid. So when parents advocate for their children, which is absolutely normal, parents do it all the time, but the minute you get into this environment, it's not necessarily looked as you being a good parent. It looks like you're interfering with the government parenting for you, and it is a very uncomfortable situation. For example, I helped a young kid that I thought the juvenile office was being extremely excessive with, where he was on the autism spectrum. He had Asperger's syndrome, and they were treating him like he should be following every other child's, milestones and behavior. And no, that's exactly why they have IEPs in the school. But this particular school district didn't even take care of this kid. He did not have a good IEP, so I had to get an advocate who specializes in IEPs to help this poor child. But that is exactly kind of the reason to get a lawyer involved, is because it's easier for us to advocate for your child than you, even though you are very competent at it. It's the reaction that gets in the way.
It's just like standing up in court and telling a jury that I'm not guilty versus he's not guilty. It just sounds better coming out of somebody else's mouth because it's kind of a self-serving deal, right?
Right.
I clicked a little early, but now this brings us to the petition. This can be filed after, during the informal supervision. It can be filed immediately if something is clearly a felony, clearly an act of violence, sex, or drugs, generally.
For stealing or burglary, parents will see
Right.
their kids in trouble for shoplifting, stealing, home burglaries.
For sure.
But a misdemeanor like trespassing wouldn't necessarily rise to the level of a petition, or it could, because even though it's a misdemeanor, it could still get there.
Yeah, and it's kind of a judgment call by the juvenile officer. I mean, the petition it's just like a prosecutor deciding whether they're going to charge and what they're going to charge. If you think about a trespass, it's not a big deal. But if this kid's blown off the last 3 informal adjustment agreements that they've had with him, and he's got a history with their office, then they're going to file a petition. They decide to pursue charges and they file it. Now, typically they file it there's the 2 ways. They can file it if it's a crime, right? And that would be a delinquency case. They would allege whatever crime it has, and then they have to use the words that if this were an adult, it would be charged as this. And then they have to use the same language as whatever charge they would say. And then there's also the status crimes, and that's what they put in the petition is they're doing conduct injurious to themselves or others. So that's where you come in with maybe they freaked out on their parents, or maybe they left, maybe they ran away for 7 days and nobody knew where they were. These are the kind of things that can be those status offenses. And it all has to be outlined in the petition. They have to serve the petition. They usually do it by summons. We will get to the situations about whether there's going to be any custody or not. But the petition,
and for the parent that's watching that doesn't know what a summons is, what do you mean by they serve by summons?
Oh, okay. So a summons generally means that if they get a report of something that is not an emergency, sometimes they get a report of something and the police have already called the parents and the parents have come and got the kid, and that's the best place for the kid right now. Maybe it's a burglary, like you were saying. And they will fill out the petition. They'll file it with the juvenile court. Juvenile court will determine when the court date for your first appearance should be. And they will fill out a summons which says, Mom and Dad, this child has been charged with in this petition. You must appear on such and such a date in the juvenile court of whatever county you're in. And then you probably will be served that by a DJO, because remember all the hats they wear. And they will also probably try to talk to you at that point. But
they're
the
coming
summons,
to your house.
right. And the summons is just a piece of paper that orders you to be there with your child.
What happens to the parent who says, I'm going to ignore this?
Well, depends. It depends on the crime, usually. Like I said, I haven't been in front of every single juvenile court judge, so it's within their power to then order the child into custody. Okay, but normally that is a last resort. I guess technically there could be some, criminal contempt kind of issues come up if you've been served. Generally, if it's not a really bad situation, they're just going to issue you another letter another summons.
And when you
But
say criminal contempt, you're referring to the parent potentially being incarcerated.
yes,
That's
yes. So
in their power.
it is. But then, if they do this 2 or 3 times and nobody's doing anything, I've seen them want to issue order to lock the child up. I've never seen them hold a parent in contempt, but as you well know, they have that power to do that if they chose. Most of the time, though, they figure if the kid gets locked up for 24 hours, mom and dad are going to figure out that they need to get their stuff together, so to speak. Um, so this I kind of talked about a little bit, but actions that hurt the child or others, that's not going to school, getting in trouble all the time at school. If you are a disruptive force and it happens, they used to kick me out of school for such behavior. Not sharing too much, I hope. But now they'll call the juvenile office and they'll send over a DJO to talk to you about it. If you're out of control at home, these are those actions that hurt child or others. And then there's breaking the law, which is a little different. We've already talked about. Now, this is my view, and it's kind of just based on my experience that drugs, violence, and sex are looked at differently than vandalism, stealing, or running away, or doing things that you would almost consider. I mean, they don't consider anything just kid stuff anymore. But in my mind, judges, and when I say drugs, I mean everything but marijuana. Judges are not down with your 14-year-old smoking pot. Don't get me wrong, but what they are not going to do is send in the cavalry if a 15-year-old gets caught with a dime bag. I mean, it's not. Most judges would at least understand that marijuana is something that can be dealt with short of locking a kid up. But I do see lots of times when it's more serious drug issues, more harder drugs, more felony drugs, any kind of felony violence, which, as you know, Kim, can be any violence. I mean, because there's such a broad spectrum of discretion that prosecutors and here juvenile officers have to allege a felony violent act. And then anything having to do with sex is usually dealt with pretty severely and quickly.
There's two things I want to talk about here before you move on.
Yeah.
Because part of this conversation for parents is to help you talk to your kids about not getting in trouble. And sometimes if I'm being honest, when a kid hears it from their parent, over 50% of the time they blow it off and don't listen to the parent. So maybe you need intervention and someone else to come in. And I've actually had a client ask me to talk to his young son to teach him the law because his son was doing some stuff and he wasn't listening to his father. So my point is the two areas that I have seen kids get into trouble in, and they are clueless and the parents are clueless that this is trouble. One is kids who have stolen, or maybe they're on their own prescription, but something to do with prescription drugs. The kid has a prescription to Xanax or Adderall, or the parent does, and the kid steals the parents. And then what happens is the kid takes that drug to school and their friends want it. They give it away, they sell it. Maybe they sell it for money. It doesn't matter. They can give it away to a friend that they think needs this medication. All of a sudden, they're a drug dealer, very serious offense, kicked out of school, serious felony, juvenile office, judge, potential locking the kid up. I mean, that one, I've seen kids who think nothing of it get in serious trouble. And the parents are even like, well, it's not that big of a deal. But unfortunately, it is. The second area that I want parents to really be aware of and talk to their kids about, or have someone else intervene and talk to their kids about, has to do with this picture right here. The cell phone with the no bra. We see children, and children could be as young as 11 and 12. I've seen it. The internet has educated children today more than 30 years ago when 11-year-olds had no clue about certain things. They now do. And we're seeing kids who take provocative pictures of themselves, put it out on Snapchat, send it to a friend, text it to a friend or their boyfriend or their girlfriend, and then all of a sudden that person who received it shows it. This is what's called child pornography, and they're getting in some serious trouble for this. the law is not written to protect the children very well from this behavior. And God forbid your 16-year-old has an 18-year-old or 17-year-old boyfriend, which is very common in school. And it was when we were kids too. The 16-year-old's dating a 17-year-old or an 18-year-old. And if this happens and the 17-year-old or 18-year-old receives the picture, they've just received child porn. If they show it to a friend, they've just distributed child porn. It is something that parents need to know about and be very wary of and talk to their kids about.
Yeah, that's just no doubt, because the sex stuff with kids, I've handled some of that in the juvenile court even, but the juvenile court doesn't deal with it well. I mean, nobody deals with those kind of situations well, but it's not real common in juvenile courts, because most of the time kids who engage in this kind of behavior, if it's alleged to be rape or something like that, or they're distributing stuff on the internet, if they're 15, 16 years old, they're trying to send them to the adult court. And we'll talk about that here in a second. But yeah, no, I couldn't agree more with the sexting issue. But I did say that, and we've kind of touched on some of this, but the juvenile court judge wears many hats, right? So we've talked about these status offenses and delinquency. They also do, like we touched on at the beginning, the child abuse and neglect cases. They also do termination of parental rights cases, adoptions, and then guardianships, which if they're going to make somebody a ward of the state, they're the person who does that. So understand that these judges, like I was just saying, have all of these things that they have to deal with. And sometimes criminal law and really looking at those issues is not their best asset. So be leery. Now, we were talking earlier about custody, and there's some pretty important things you need to understand about custody. Any law enforcement officer can arrest a child, okay? If they have probable cause to believe that child has committed a crime. And what that means in an officer's mind may be something different than what it means in my mind, but basically, if they have a reasonable belief or a good idea that this child has committed what would be some kind of felony or misdemeanor, they can arrest the child. Now, they can't take a child to regular jail. They can hold a child in a police station in a non-locked environment or a non.
Can or cannot.
They can, but it can be in the office, but it cannot be in their holding cell.
So basically, behind bars or behind a locked door in a locked room by themselves is not permissible.
Right, and they can't see or hear any adults in their holding facility either. That's one of the rules, and I get why it's a rule, but it really is one of the rules. So if they hold a kid, they'll do it in their office or in the conference room in their lobby or whatever. Sometimes that can happen when they're calling parents or doing that.
Can they use handcuffs?
They can, for officer safety. Now, a lot of that's going to depend on what police you're dealing with, what department.
And the reaction of the kid. If the kid's out of control and flailing, right, that's different than a very compliant kid.
True. And, in the age of cell phones, I mean, I think most police officers are going to try to get a hold of parents first, unless it's something super serious. I would always teach your kids that if they interact with a police officer at all, that they need to ask to call their parents, and they need to. And I know somebody would have told me at 16 that if I see a police officer that I should ask him to call my parents, that would have been the last thing from my mind. But if I were ever accused of something serious, and that doesn't mean that the kid did it, that just means somebody's accusing them of something, they need to call their parent, or get a lawyer that they can call too. The assumption is always that they go home. That is written into the law. It's in section 211, which is where all this stuff is. The assumption is that kids go home. And if it's such a bad crime, it's like what I said down there, my three are sex, violence, and drugs. If it's pretty bad and that's that, then they can lock them up, but they have to take them overnight to a secured juvenile facility that only houses juveniles. Those are only manned by the juvenile office in the counties that they reside. So, for instance, Jackson County has a couple of juvenile facilities. Cass County, where we sit, has a juvenile facility, and that is the juvenile facility for the whole circuit, which is both Warrensburg or Johnson County, Missouri, and Cass County, Missouri. The further you get out into the middle of Missouri, the more often you'll have 3 or 4 counties that only use one juvenile facility. The trick is, though, they have to see a judge within 24 hours. So if a kid is being held, they have to be in front of a judge within 24 hours. Now, usually parents are contacted for that hearing. Most juvenile officers are pretty conscientious. There's a publication, I think it's from 2016. It's a best practices that was published here in Missouri, Juvenile Officers Best Practices Guide or something along those lines. And I've reviewed it, and it does really give that the best practice is to let the parents come. And also the best practice is to have the kid an attorney before he goes. So that means that when I was on contract with the juvenile court, that I would get a call sometimes from the clerk at 8:30 and say, hey, we're going to have this custody hearing at 9. Can you be here? I'm like, well, okay. Sometimes I'd appear by phone, but they would send me all the petition would have to be done by then. They also do a standardized form that is designed to be able to tell the judge whether this kid is a real threat to the community or himself. You definitely want somebody to read that who's read it and worked through that a few times, because these are all check boxes that a DJO decides to check, which can impact how the judge looks at your kid. So
I have
for
a question
instance,
for you.
oh yeah, go ahead, Kim.
You said 24 hours they have to see a judge, and before COVID, that was almost primarily in person. Now We're seeing more Zoom or WebEx video conference type experience, aren't we, with even the juvenile?
Yeah. No, I would imagine.
Everybody.
I would imagine that can be accomplished through WebEx or Zoom, whatever they're using, because the thrust of the law is that the judge has to find probable cause before he can allow the kid to be locked up any longer.
Well, let's say the kid got taken into custody 6 o'clock on Friday night. Is the 24-hour rule going to mean 6 o'clock on Saturday or 6 o'clock on Monday?
It'll be
when the
Monday.
Judge comes back to work.
It'll be Monday. They built in state holidays and weekends to that. So yeah, if it's a Friday night and a kid goes in, it will probably sit there till Monday. Now, if you know the right people to call, you can also call them and say, hey, I've got parents that are on board, and you can talk through that and sometimes get that done, because again, the assumption is that they go home.
Right.
That's the assumption. So it better be pretty grave, or such a situation that they can't guarantee the kid's safety or the community's safety if they go home and are with their parents. Sometimes that isn't an option, though. I mean, we all know that parents are not perfect, but generally they do go home with their parents, because really, other than some pretty violent crimes, there's just no reason to keep a kid locked up. So that gives you, if you are released pending trial, pending adjudication, that's the juvenile court word for it, you get your DJO anyway. So you get ordered by the judge to do certain things. And usually, depending on the thing that's alleged, the crime that's you're accused of, the judge will make you meet anywhere from once a week to once a month with the DJO. They can put you on house arrest. They can come home with their parents, right? So they can put you on house arrest with your parents. They can go home with a family member or even a friend. I've had a friend come through for a family at one point that the juvenile officer didn't feel like the single parent dad was enough supervision because he was gone so long for work every day. They had a family friend who stood up and said, hey, we are lucky enough to have a parent at home during the day and be there when school's over, and we'd be happy to have him come stay with us. It's really anywhere that's appropriate and can keep the child safe, and also everywhere else. So it doesn't necessarily mean you have to put bars on your windows, but they are pretty serious about it. If they see a kid out running around, that DJO will go right back and tell the judge, and they'll have a problem with that. They normally don't order services at this point. However, I have seen in situations where a drug issue is so profound or so difficult that they do order them into some kind of treatment or some kind of counseling for that. Most of the time, though, it's just supervision, drug tests, maybe, if that's appropriate. When you go to meet with your DJO, they will have you do a drug test. But most of the time, this is where people are.
Craig,
Yeah.
generally speaking, how long of a time frame? From the moment your child got arrested to that trial, what kind of release period are we talking about here?
Okay, so juvenile courts are on a bit of a different time frame. They have what they call keystones that they need to be hitting these keystones to move people through. And you can imagine that they don't usually, that you would have a trial in a kid case like this within about 90 to 120 days would be the outside. Now,
and that's quick. Adult court is much longer. Usually, right. The benefit of us, we can't get ready for trial that fast, especially, I mean, there are so many things to do to get ready for a trial. It would mean a lawyer has one client.
Right. No, and that's where the kind of the rubber hits the road. So I did have a multi-count juvenile sex case in Warrensburg when I was there, and the judge had to, I had to get, because it was an appointed case, I had to get money approved from the judge for depositions. I had to get releases signed by the judge for the kids that were accusing him records. I had to get, there was just so much going on that case ended up, it was almost a year before it was done. But the judge saw the work, I was going back every couple of weeks with, I need this now. I need this now. So that if it's a reasonable delay, they're going to give it to you. Yeah. But if it's just delay for delay's sakes, a juvenile court is not going to do it. They're going to have their trial. Now, the trials, though, are called adjudications. It's the same standard, though. It's got to be proven beyond a reasonable doubt. That's when a kid's charged with a crime. It is not a different standard, so it isn't any lower. A lot of standards in juvenile court are a preponderance of the evidence standard, which is super low compared to beyond a reasonable doubt. So that is a good thing. However, bad thing is it's a judge, and a judge has to be the one that does it. There are no juvenile court jury rights. So that is one difference between the juvenile court. However, you get the same trial rights. So you get to confront your accusers, face-to-face confrontation. A lot of times in juvenile court, the DJO will come in and read a report from an officer. In the trial, in the adjudication involving a matter like this, they can't do that. And that's a little different. And quite honestly, it kind of pushes some of the attorneys that work for the juvenile offices, it pushes their boundaries a little bit, because they normally get away with just kind of ignoring evidentiary rules. And that's good. Also, you get to cross-examine people. And that is, I mean, I can recall how important that is in a trial before a judge, because on a piece of paper, if some doctor writes, well, this was certainly a non-accidental injury, and then you can confront them with the idea that there's no difference between this injury and this is a burn case I'm talking about, but there's no difference. There's no way to prove that anybody held them there to be burned or that anybody intentionally burned them. There's nothing in the science that says that, is it? No, it's just you are the child abuse clinic, so that's what you do. And that's impactful to a judge, because if a judge reads that on a piece of paper, it's a big difference than having somebody stand there and explain their position. So that's good.
This, the audience are parents, not lawyers. And so
Right,
a lot
right.
of this legal stuff here, but for parents to understand that your son or daughter gets a chance to really attack the evidence and present evidence, and they're not just railroaded into a conviction because somebody's reading a police report that an officer wrote down because he interviewed X, Y, and Z people and all this stuff that's not reliable. And that's why we don't let hearsay into trials, because hearsay is not reliable. Either
Right.
you're going to hear from the horse's mouth, so to speak, or you're not. And so when it comes to trial rights, I think that's really the only thing that's important to parents is your kid will have a chance to have a defense.
Yep. And that would involve any evidence or witnesses that the family or the kid wants to bring too. Kids can't
the same right not to testify.
Right. They have the ability to testify and the ability not to testify.
Yeah.
And generally, kids can present documents with an affidavit too, but that's a little more legally than I think you wanted me to get into. So what happens if you're guilty? First thing I'll say is if you're innocent, then you go home, and the juvenile office hopefully will stay out of your lives.
If you're found innocent, I have to say, because there's plenty of innocent kids who get found guilty too, just like in adult court.
That's true.
So if the judge finds you innocent.
Right. So most of what happens is that you get an adjustment, which is probation. Most of the time, if you lose a trial, the judge is going to find classes, service, community service.
Reporting to your DJO, weekly,
Right.
monthly, whatever.
Right.
They can look at your attendance records. They can look at your grades. They can really dig into the kid's life during probation to make sure he's walking the straight and narrow.
Well, and they bring them back normally every 90 days or so to see them. A lot of judges do. And they get reports from their DJO about their attendance and their drug tests and what classes they've gotten done, and if they've gotten their community service over with, or, whatever. Some judges are real hands-on like that.
And I think also the difference in juvenile court from adult court is the parents who are watching this, your life is kind of under a microscope too, not just your kids. Because believe you me, if you're drinking too much or not at home enough, or you also smoke weed, or maybe you have an opioid problem due to an injury that led to an addiction, or you're dealing with mental health issues, All of that is getting reported to the judge and being considered as to what to do with this child, and potentially the child might not be able to stay with you. And I have seen cases where, because nobody else stepped in to help this kid, that child went to DYS because of bad parenting. And I was livid when I learned that that was what the juvenile system could do if they can't find a place to put the kid. If the kid's still acting up and probation is a struggle because of bad parenting or a bad home life, that they decide the cure is DYS, which DYS to me is punishment. I've never had a kid describe DYS as anything but punishment, and it can get pretty horrific depending on their experience.
Right, for sure. And I listed the website there that has the about DYS.
They try to make
DYS.
it sound like camp or it's a good place to go. But my experience years ago of learning what DYS really is was that's not the case. They wish it was. They try for it to be, but they don't have enough. The problem is the government doesn't fund DYS. So you might have 30 children to one adult, and these children, some of them are much smarter and savvier and street smarter than that adult. And so the kids are ruling it. It's very much due to lack of funding and lack of paying well enough for adult supervision. Sometimes it's the kids are running, I don't know, they call it, the inmates are running the jail. It's a similar thing. Lord of the Flies almost.
Right. Yeah, and I mean they have made efforts to do more in the last 10, 15 years, but it still is not ideal.
No, not ideal.
I think you're 100% right. Certainly on the lockdown facilities, the facilities that are like kiddie jail, I mean, that's just housing the kids, and it's not, it's just not a good environment. I think that there's plenty of good people trying, but like you said, they don't have enough money or time to really impact the kids. So, and I think a lot of judges know that, and most of the judges that I've dealt with really look at that as a last resort. Even for a kid that's found guilty of something pretty serious, if they've done well on their at-home or their pre-adjustment supervision, if they're reacting well to working with the juvenile office, if they're staying out of trouble now, if they're not, using drugs or running the streets, then typically they go out of their way to figure out how not to send them to DYS. But there is kind of a culture of, if they're not going to do it, send them to DYS. Certainly as you get further away from the city centers in Missouri.
Yeah, I was at the Lake of the Ozarks when I would handle juvenile cases, and that's where I saw it, and it was really sad.
Yeah, and I'm not here to badmouth any region, but they're all regional too. So there are facilities southern Missouri, western Missouri, and eastern Missouri.
Yes.
And they all kind of have their own
culture.
They have their own culture, but they also have their own kind of maximum security, and they have their sex offender units, and they have their own different things, and they're all aimed to do the same thing. But I don't know that they're real successful. But I have had a few older kids come out of there okay, but it's kind of
one thing I think that parents care about on this topic, and it may be a future slide, but I think parents care about, how does this entire experience affect my child's future? What's going to be public? What can haunt them into their adulthood and what can't? Right. There is a sex offender registry for juveniles in Missouri. What does that mean to the parent? How does the child get on it or off of it? Let's talk about that a little bit.
Yeah, we sure can. I don't know that I have a slide on it.
Maybe was that the last slide?
That's the end of it, sure.
Okay.
But yeah, no, I had hoped that we would have more than just the, because I also want to talk about certification. But as far as the sex offender registry, now I am a complete skeptic about what they do with this. The registry is kept by the juvenile officer in the county where the child lives. Mm-hmm. And they have to register until they're 18 years old. Now, SORNA, which is just the federal law, says something a little different than the Missouri law says. So it's really a case-by-case basis about what crimes are alleged and what things you admit to, um, whether or not you have to continue to um, report as an adult. It's not something that I can just sit here and say, if you plead guilty at 16 of rape, well, you're not going to have to report when you're 18. You might very well have to. It's a case by case basis. They look at the federal law, looks at what the age of the complaining witness is, what the age of the person who committed the crime is, whether violence was involved.
And in sex crimes, we're not necessarily talking about like a rape, like you think of one person wants the sex and the other person says no and it happens anyway. That's not at all what we're talking about. There are plenty of statutory cases where a 16-year-old boy and a 14-year-old girl, and then they call him the criminal even though they're both juveniles. Wouldn't you agree?
Oh yeah,
A
I
lot.
mean, it depends. It's almost whose dad's more pissed off. Sometimes, or whose dad owns the local hardware store or whatever.
Sad but true.
But that's it. I mean, is almost, I would almost say if the boy or the girl who's older, whoever is older, whoever has a prior with that juvenile office is probably going to be the one that gets charged, because juvenile offices are kind of microcosms of small towns from what I've seen. Now in the bigger cities, it's a different deal, but they still have, these people live in this area and they're from this family and they're all bad.
And
So
I'm
they're
going to tell you
always
a horrific story that was in downtown. It was Kansas City, Jackson County Juvenile Court.
right.
About 15 years ago, I represented a young boy who was accused of basically playing doctor with a young girl. She was 3, he was 8. 8 years old, we were in juvenile court. Judge deciding what to do with an 8-year-old. It was absolutely ludicrous.
Yeah.
Absolutely ludicrous.
And because we've had to talk to these people about why they're doing the things they're doing, and I still can't explain sometimes why they make the choices they make.
Are you referring to the 8-year-old or to the juvenile office?
The juvenile office. But yeah, because the person who's making the choice to push charges on this juvenile, whoever it is, whether he's 8 or 15, is the juvenile officer, right?
Yeah,
So
there was a petition against an 8-year-old. It's not the first time. And this was Kansas City, where you think that things are a little bit different than in the country, and that the country is a little harsher.
Mm-hmm. Huh. Yeah, I haven't experienced that one in the city, but the thing is when you go to the attorney for the juvenile office and start asking them, why are we doing this? What is this going to? Well, my client says we have to do this, and I'm like, well,
You don't have a client.
Well, they do, because they work for the juvenile officer.
Oh, the attorney. Okay, the attorney.
Right.
Okay.
Not
the attorney for the juvenile office says my client wants this, and their client is the juvenile officer who's supposed to represent the community.
Right.
And they're making these terrible decisions about how to handle children. And if they are particularly biased or prejudiced against, whether it be culture, ethnicity, gender, and God forbid they have any misunderstanding about children who explore bodies, and then they're going to call it a sex crime. And any child psychologist could talk to them and educate them, and if they would just listen to the truth of the matter about how children learn about their bodies and learn about each other's bodies, and how it even cross genders. And it's not sex. It has nothing to do with sex. It just happens to be genitals. That's what's so frustrating.
Right. And usually, from what I've found, and I'm sure you'll tell me if I'm wrong, but when I have a kid who's really doing something hypersexual, it typically means that they've had trauma in their life and that they've had to experience some kind of abuse themselves. And that's not when you get punitive. That's not where you take a kid and make their lives worse with more trauma and more adults doing things that they don't want to deal with adults doing. So yeah, it's tough, and it's all run. The juvenile officer is the one who really runs the show. So
today in this discussion, tip number one was talk to a lawyer. Don't talk to the police. Don't talk to children's division. Don't talk to the teacher, the counselor, the principal. Talk to a lawyer first. Figure out what you're dealing with and how to handle it, even if it's just a couple hours of a lawyer's time. And not just any lawyer. Don't call the lawyer who did your divorce. Talk to a lawyer who specializes and understands the juvenile court system, because it is an animal unlike any other. I compare it to, do not call your family doctor for heart surgery. Just obvious, right? It's the same thing here. And another tip was how to prevent certain things, because we see children who get in trouble in the area of drugs where they're like, this is no big deal. And even the parents can be guilty of that, feeling that this is not that big of a deal. Why are we going to the nth degree, kicking my kid out of school and filing a petition and seeing a judge for this behavior that was normal when I was a kid?
Yeah.
And also parents today, I think parents feel very frustrated with the system, that my kid would be better if you would let me spank my kid. And I'm frustrated that corporal punishment is basically frowned upon, even though it's still legal. I'm being judged if I use corporal punishment, but by God, my kid would be better if you just let me spank him with a belt. And there's a lot of parents who feel that way.
Oh, yeah, mine did. But that's probably over the bounds these days.
These days, yeah. And frankly, I'll never forget when I told my dad, because I was spanked as a kid, and years later, I'm 22 years old, and I said, Dad, I don't remember all the spankings. Mom and Dad both spanked. What I remember is the one time you sat down with me and I thought I was getting a spanking and you didn't spank me. That conversation we had that day and the fear of being spanked was much more powerful than being spanked. But I have to say, corporal punishment was in my childhood. I don't look negatively upon it. I think it's absolutely necessary for certain kids to learn how to fear authority and to act a certain way and be in line with the rules.
Mm-hmm. Yeah, I don't get to hit my kids, so.
But and every parent's different.
They were born in the 2000s, so no. But I mean, I certainly understand if you use it as a tool that it can work,
and it certainly can get out of hand, no question.
Yeah, and that's just we're kind of digressing now, I think.
So if we were to wrap it up for the parents that are watching this, and the goal was to be educated about what happens if my kid gets arrested, or if law enforcement wants to talk to my children, or the school, we're having trouble in school and it's getting the juvenile court or the DFS involved. Any last minute suggestions?
Well, I mean, always find out what they're accusing you of, or your kid of, okay? Ask questions. Don't answer them. Ask questions. What are you going to do now? What are you saying he did? Can we set up a time to meet? I mean, don't do anything fast, because right. if you do it unprepared without any consultation with a lawyer, really, you will end up making mistakes for your kid. Do not get mad. When you get mad at these people, then they are out for you. Then it's not about your kid anymore. It's about their crappy parent. So really, really watch your tone, because you know what? If somebody came at me about one of my kids and said he's this X, Y, and Z, and I knew he's not, I would be cussing and telling him where to go. So, but you can't, because these are the people that are making those discretionary decisions about what to go after your kid with. And if they think dad's an asshole, they don't think they can work with dad. Well, guess what? They're probably going to go to the judge because the judge can order dad to do stuff. So that's it. Ask questions, keep your cool, and always call a lawyer. Don't, I mean, just know the smallest of details could end up making their case. So you got
Yeah.
to really think about it.
Well, that's a good ending to this presentation, and hopefully some parents learned something to help protect their kids. Thank you, Craig.
No problem. I'm going to email our landlord though, because it's hot in here. So.